Knight versus Dewitt Rehabilitation and Nursing Center.
Good afternoon. May it please the court. My name is William O'Connell from Goldberg Segala, and I represent the defendant appellant DeWitt Rehabilitation and Nursing Center. This is a case about a forum selection clause.
But before you get to the forum selection clause
Certainly, Your Honor.
and get the benefit of that clause, don't you have to first have a valid contract?
Your Honor, I believe you have to, my client, as the person seeking to assert the forum clause, has to make an initial showing that the clause was applicable and enforceable, and I believe we made a very strong initial showing of that.
How do you do that? What's the method for authenticating a contract?
The method in this case is circumstantial evidence, and we provided a host of it. We provided two 44-page admission agreements with DocuSign initials and signatures of the decedent, which resembled it, but
You never made that argument to the Supreme Court, though, right? That it was authenticated via circumstantial evidence.
Well, we used circumstantial evidence only. We did not have direct evidence of any witness or anybody who could say that the decedent signed it. And later on, counsel in his opening brief to the appellate division put in a footnote that that is another way of proving to authenticate a contract. And that was the type of evidence we used, and I did start using that term, although I didn't use it in the beginning in the Supreme Court.
Counsel,
yes.
let me ask you this. You started off saying this is a forum selection clause, and it seems to me this is a subset of a forum selection clause, right? Because it's a intra-state forum selection clause. It's a venue motion. You could have a forum selection clause that says this case should be brought in Minnesota, right? You don't move to dismiss, you don't move under Article 5 and 501 in that case, right?
Correct.
So you're bringing a motion under 501 and 510, whatever. Do you think the standard in considering the contract in that case is the same as considering it for a change of venue out of the state, or a motion for summary judgment, or even a motion to dismiss, or a trial exhibit? You know, it's going to go into a trial, or is it something else?
I believe the standard is different. I believe it's lesser, certainly, than a summary judgment standard, as I...
How would you quantify that difference?
Well, I would quantify it by making clear from the case law, which is the Court of Appeals has said, in this case, forum selection clause is prima facie valid and enforceable unless shown by the resisting party to be unreasonable, and then the longer appellate...
To me, that goes more to the issue of you have a valid contract. What do you have to do to get out from under that venue selection clause in a valid contract? You're not disputing you have a contract. You're saying you shouldn't enforce the venue part of that. That, to me, is a very different burden than the burden on the proponent of enforcement coming forward and saying, this isn't a document I found on the street, and, you know, hey, whatever, it has your signature on it, and in some way authenticating for the court that this is an agreement where you have agreed to this venue change.
Your Honor, if I understand, it's our position that there is an initial showing that has to be made, and that's lesser than the showing that would ultimately have to be made.
I'm having the same difficulty, I think, which is I'm not sure why. The question here isn't just, the question, it seems to me, is just, is this signature authentic, right? I mean, if this has been a contract for the sale of widgets as opposed to the contract for the admission to a nursing home, I'm not sure why the analysis about how to authenticate the signature is any different. It's just a contract.
Well, fair enough, Your Honor, and I can just speak really to the authentication. In this case, it can be by circumstantial evidence, and in our case, we provided two agreements with multiple signatures, with a statement, a notice statement in it that says that the resident's entry into this facility is conditioned on the execution of this agreement, which certainly suggests that she would not have gone into the facility, which she did, and they don't dispute that on the dates when these were signed, that she actually went into the facility, and well, really, that's it.
But counsel, isn't that a little different? That, you know, the circumstantial evidence you're talking about would tend to show that that is the genuine contract that you have on file at your business. But it doesn't really address the question, which is the core issue in the case, whether this is the individual who executed that contract. It's different. And I don't know that any of the circumstantial evidence that you put in, and correct me if I'm wrong, please, actually tends to establish the authenticity of the signer.
Well, I respectfully disagree with that, Your Honor. I mean, if we have two admission agreements that were allegedly signed by the decedent,
Yeah.
and the decedent was in the facility on those dates and signed an agreement that said, or allegedly signed an agreement that said it's conditioned on your execution.
Fair enough, counsel, but you didn't have the person who was in the room, allegedly, with the petitioner when she signed the contract to say, you know, I was in the room with this person, and I told them that they can't be admitted unless they sign this agreement, and that's when they signed the agreement. None of that is part of your circumstantial evidence in this case, right?
No, and that wouldn't be circumstantial evidence anyway. That would be
pretty
direct
direct
evidence.
evidence,
But
yeah.
we don't have that person. Obviously, they were unavailable, and they could not sign this. So we had to put in the evidence that we did have, and we did on our motion to change
So
venue.
when it's challenged, if the validity of the contract is challenged by the other side, then you don't necessarily have the proof. There's a question. There's a question of fact as to, is it valid or is it invalid? There's a contest going on. Many of the cases that were cited are cases where it's assumed the contract is valid, and you're just going to the venue aspect.
That's true, Your Honor. But I'll give you one case, the Chow case, which I mentioned in my briefs at both levels, and that was a case where there also was a disputed fact about whether the son who signed an admission agreement.
That case, they signed it, they accepted, they signed it. It wasn't the son didn't sign the contract. The question there was, the son have authority to sign the
Authority.
contract, which is a very different issue than we have here.
With respect, Judge, I don't see how. Doesn't that go to the authority of the,
Let's
and
say
the
they came in
enforceability?
and
I'm sorry.
They said, the son says, I never signed that. That's our case. That case was, I signed that, but I didn't have authority to sign that. So you're not contesting that the document's authentic or not authentic. You're contesting the power of the person to enter into the agreement.
True, but isn't the result the same? The result is that the forum clause can't be enforced because there's either not an authenticated signature or because someone didn't have authority to sign
The
it.
grounds are very different, which affects the analysis. But let me ask you a different question. I understand your point about the circumstantial evidence that you proffered. What if all you did was put forward the signature alleging that it was hers? That's it. The signature, the initials, and that was all you put forward.
I would say, and.
Is that enough? I'm just trying to see where this
Not
line
enough.
is drawn.
Not enough.
That's not enough. Why is that not enough?
It's not enough because it didn't have the additional evidence that we had in this case, which included the Tremarchi affidavit,
So
which went.
let me ask you a
Yes, sir.
general proposition. So if somebody shows up in court with a contract that's signed,
Yes.
right, and and signed by the counterparty, and the other side says, well, this is not my signature, is there a presumption that the contract is valid, or a different way of asking the signature is valid, or is there, a different way of asking it is, whose burden is it initially to come forward with evidence that the signature on the contract is not what it appears to be?
I think in the initial showing that would be made in any sort of contract case would be my burden to make a showing that it was the decedent's signature. And I believe we did that.
So
Did we
you
prove
agree
it
that
with-
you
I'm
have that?
Yes,
Sorry,
Judge.
maybe I wasn't following your arguments. I thought in your brief you were suggesting that you have no burden to show authentication, as opposed to arguing that you have successfully met that burden. So are you agreeing that you do have some obligation to show that the contract is authentic? And if so, what exactly is the nature of that burden?
I believe we do have an initial burden, and there is, in New York law, there are phrases like that, initial showing, that are lesser. It can be, in my brief, I mentioned jurisdiction. There are some limited things where you have to make an initial showing, but you don't have the burden of proof entirely, the burden of persuasion.
wait,
So you have a
what-
burden of production
I have
with
an-
respect to the document,
I do have a burden of production.
but you
and-
don't have the burden of persuasion. So if there's a claim, like Chief Judge said, that's not my signature, it's not your burden to persuade that that is an authentic signature. It's the person who's contesting it, or am I
No,
misapprehending your argument?
that's exactly right.
How does that work?
The signature doesn't satisfy the burden of production or doesn't satisfy the burden of persuasion? The signature on its own, what I started out asking you about,
It satisfies the burden of production.
but not necessarily persuasion. if it's
Correct, but
challenged.
the other factors that I've mentioned also strengthen my initial showing and my initial burden to show that this of course is the decedent. I mean, she's there.
Well, let me ask you,
Yes,
try my
Chief
question a
Judge.
different way. Same contract for widgets, I come into court, it's signed, right? And my adversary says, wait, this is not my signature. Is that enough then to put that at issue? Or do they have to, do they need an affidavit from the person whose signature it is saying, this is not actually my signature? What do they need to do?
Your factual said that the person came in and said, that's not my signature,
Let's say that,
correct?
yeah, let's say that they say that under oath. That's sufficient, I assume, to put it under, right? What if
Well, I would say it's fairly compelling information, but
Okay, but you might be able to prove otherwise.
might be able to prove
Right.
otherwise.
So let's say you don't have an affidavit from that person, the other party's papers just assert this is not actually the signatory's signature. Just that assertion with no proof. What happens then? Your burden? Their burden to put something in?
The burden itself is on the person who's challenging
Okay.
that clause,
So
and
they've
it
got
remains
to put
there.
in something with evidentiary value to raise that issue, not simply assert it. Is
Correct.
that okay.
And in this case, obviously, once we shift over to the opponents, this court has used the phrase in one of its cases.
Well, and here they did put in something, right? They put in an
They did.
exemplar, and
They
they
did.
put in, right?
And it was, in the terms of this court, no more than a bald assertion of forgery.
Even with an exemplar.
Even with an exemplar that's unidentified, it was not told where the document came from. It had two signatures of the decedent and apparently her
Well, doesn't that
husband.
go to the weight to be afforded that particular piece of evidence that they were putting in?
Well, I understand, and I'm
Versus
explaining.
whether or not they produced anything.
Well, they did produce some evidence, and it's my opinion that under the case law, that really doesn't satisfy it. There's no handwriting expert. They don't identify the exemplar where it came from. The statute speaks on that, the CPLR. The comparison is weak. It's between a handwritten and a DocuSign signature, so.
So your rule, as I understand it, is to meet your burden of persuasion, not yours, for your adversary to have met their burden of persuasion with respect to the authenticity of the signature, they would have to establish the authenticity of the exemplar, A, and then produce some competent evidence as to why the two examples don't match up, i.e. they'd have to call a handwriting expert to say that these are not the same signature.
Yes, I'll just qualify that. The law does say that they don't have to actually produce a handwriting expert, but obviously it would make the proof that much more persuasive if they did. In this case, they didn't, and it's the plaintiff himself who's giving his handwriting opinions.
So your position is you produce the contract, and then your adversary says, not her signature, obviously she's deceased, we can't get an affidavit from her, and then the burden of persuasion flips, is this your view, to your adversary to show that in fact it's not her signature?
Yes, that is my position, and that position, you have to look at the other avenues in the standard, and whether it's overreaching or fraud or in violation of contravention of public policy, not all easy things to prove either, I would say, but that is the case law burden that we've had, and the First Department followed it for a long time until this case, and we've already discussed. Yes.
If your adversary had authenticated the exemplar, would that have been enough? I thought I heard you say the handwriting expert would have been helpful but not necessary.
Yeah.
So the authentication of the exemplar would have been sufficient to meet the burden of persuasion, or to push it back to you?
Yeah, I don't think it would have been sufficient.
So what would have been needed if a handwriting expert was not necessary?
I'm not sure what would have been. I think it would be very close in terms of deciding who prevails in that point, but that's where this case really comes down to, is who has the burden in the first place. And
Does it come down to that, or does it come down to the Supreme Court here had the exemplar in front of it, and it made a factual determination that the two were not, that was not sufficient to meet, to show that these signatures were not hers. But, perhaps with the date on the exemplar or something like that, couldn't Supreme Court have made the other finding?
Well, the Supreme Court, in this case, ruled in my client's
Right,
favor.
but
Okay,
right,
I thought you
right.
said the opposite,
No,
I'm
no,
sorry.
ruled in your, but there
I
is
misheard.
evidence here, and couldn't essentially, we've got a factual finding from Supreme Court.
Right.
And there is some point where, the exemplar is a little bit better, or whatever it is, where Supreme Court could have found against you.
That is
And there's
possible.
nothing much we could do about that, because that's a finding of fact based on evidence in the record.
Right, but that's not what happened here,
understand
and
that.
it's a DocuSign signature, and that comparison is really not really ever going
But
to
for
work.
example, if there had been a DocuSign signature from Mrs. Knight a year earlier, and they looked very different,
Different case.
right.
Your Honor, if there are any other questions, I appreciate it. Thank you.
Thank you.
Good afternoon, Your Honors.
Who has the initial burden with respect to the validity of the contract itself?
So, with the respect to the validity of the contract itself,
Before you get to venue or forum, don't you have to first have a valid contract?
I would say to that, yes, of course. But
And was the validity of the contract challenged here?
it's hard to answer that question without first recognizing the fact that as lawyers, we're only supposed to look at things that are actually in evidence that we can consider. So while the issues of forgery or forum selection are interesting, and while I understand that, that my colleague here would want to make this case about forum selection, which is a loser of an argument for me, I'll confess something to you that I probably shouldn't in the Court of Appeals, my first time ever here. I never really understood that there was the need for a dual statement in the business record exception to hearsay. I never really understood why a document had to be made in the ordinary course of business and then
But
it
can I
was.
stop you there? Because I don't understand that we're talking about hearsay at all, right? This is just authentication.
But there's no document that we should even be looking at. They
Well,
haven't
there's a-
figured out any way whatsoever to admit this contract to the court.
There's a contract, and it
Maybe.
has, well, there's an agreement. It's titled agreement. I know, you're saying that your client didn't sign it, or we don't know that your client signed it, right?
It's just a
But
piece
there
of
is-
paper.
There is a piece of paper that has terms in it, and it has initials on the bottom of the pages, and it has signatures in various places.
I agree with you.
Okay. So I think I agree with you that this is not about a forum selection clause, and this has nothing to do with the law on forum selection clauses,
agree with
right?
that.
This is just about what has to be done to authenticate a signature on a contract.
Well, that's one way of looking at it, except that whether you look at a signature on a contract which has been admitted into evidence through the business record exception or some other exception, or else
No, I
whether
don't-
the contract itself has a valid signature
So
on it.
your idea of this case would be they just forgot to put half the business record sentence in their affidavit, and otherwise it would have been fine, but since that's what we're deciding as the Court of Appeals, they left out half the hearsay exception rule, so you win.
I would say at that point, once there's an actual document and evidence to look at, the burden would become more difficult for proving.
But this case, we could just decide by saying they forgot to put half the business record rule.
Not only could you decide that, but you should.
But
So-
that rule, I think, has a lot of sway to me. If a judge is looking at a document and saying, is this going back into the jury room, particularly in a criminal trial, hearsay exceptions, this is a venue change motion. They come forward and they say, this is a contract, they put in what they put in, circumstantially, let's say, or indicia of reliability. this is what it is. Is that enough to shift it to you to come in and say, yeah, well, that may be a contract, but I didn't sign it? So I'm having trouble understanding where this, the chief judge, I think, was getting at, hearsay rule comes in with respect to a judge who's making a determination on a venue change motion.
So the
Because then
question
it would
is,
be easy, just put in a business record all the time.
yeah, if they had put in a business record exception, we'd be in a different position right now. I think we would.
So how do you do?
Also,
how-
I
go
would
ahead,
say,
finish.
the question that that the Court of Appeals here really has to answer, which is going to be very difficult for you to answer, is where is Morales, right? Because that's the person who signed all
Let's
of
say
these
in an ordinary
documents.
case, Morales has died. Hope not, but let's say he has. So that means they never get the contract in.
No, there are other ways to authenticate contracts.
What are
There's-
those other ways?
There's lists of ways.
So
I
why
mean,
can't they do it circumstantially?
Why can't they? I think they can.
So then it just becomes a debate over whether this was enough.
Well, I don't think they did do it circumstantially, yes.
It strikes me part of the confusion is, it's a contracts case. They say they have a contract, they say they have an agreement, they say it was signed by the decedent. Your position is there is no written agreement, which I don't know what your claim is going to be based on, but you're saying there is no written agreement, full stop. And then they come back and say, here is some circumstantial evidence as to why indeed this is the decedent's signature, which is what you're calling this business rule exception, right? This is the way we otherwise maintain this kind of a document. That's, I think, if I'm hearing you correctly, that's where you're making this argument
If I
about the
could
business
try like a
rule.
different
Oh,
way.
But, well, yeah, okay.
I-
But just to be clear, if we just stop with it's a contract and they're arguing that this is the decedent's signature, right, and they make that statement, and you come in and say, no, it is not, and here's some evidence on my side to show you that it's not.
So if they authenticated it properly, the document itself, and now the document's in court, and then they had an affidavit from Morales saying, I witnessed the signature itself, and then we alleged forgery, I would say yes, we'd be
So
in a very...
how do you deal with our Banco Popular case?
Can you refresh me a little bit?
Sure.
Sorry.
So I can read you from it, basically. Somebody named Albaz submitted an affidavit in opposition to the motion in which she claimed that her own signature on the bank documents had been forged. She tendered exemplars of her signature to an expert. The expert
Yes, I'm
opined,
familiar.
right?
I'm familiar with
And
it.
we said, this doesn't get you there. You
Yeah.
have less here than that.
In that case, the expert was, there was a hearing held, and the expert was determined to be equivocal about whether the signature...
Right, and here you don't have an expert at all.
Well,
which
we don't
is
have a
less-
document at
Which is
all.
less, well, no, that's not true.
You've shifted the burden to us now to prove
That's
forgery.
exactly, I think, what Banco Popular says.
No, I
She
think-
alleged forgery. She said, this is not my signature. She herself said that, right?
In Banco Popular, there was already a document that was authenticated, that was in evidence, and now she was saying, hey, that's not...
What's
they-
the document in evidence,
The contract.
right? There's a contract here.
I don't know
She's
how
saying
there
the
is
same,
a contract here.
she's saying the same thing, too. She's saying, this is not my signature on this document.
No, but if we had said, hey, look, let's all agree that we're going to admit this contract, and now we're going to claim that it's forgery, and you're going to claim that it's authentic, then we'd be fighting
So are
over
you
a
saying
signature.
that the
Okay, let's say we
validity-
disagree with you, and we say, as the chief judge has been suggesting to you, it's a contract. Contract is in, and it is about authentication. Is then Banco Popular basically control and you've lost?
Well, no, I mean, I think in that case, there's a hearing held to determine the credibility of this expert and their opinion, and it was found to be an equivocal opinion on
Well, if
some.
you'd had an expert, then they could have had a hearing, but you have less. You don't even have an equivocal
They
expert.
could
You
have had a
no
hearing
expert.
on my, there's no expert needed, that's clearly been determined. So they could have had a hearing on the validity of the decedent's son, who says that's not the signature.
Right? The court heard that, right?
No.
It just like here, Ms. Albaz said, this is not my own signature.
The court didn't take any evidence of any kind. Judge Kelly just looked and said, this is a bald assertion of forgery, and it's
Right,
not
because-
enough.
Because you didn't tender an affidavit saying this is not my mother's signature.
We did.
Well, then there's evidence. Then we're going in circles here.
Sorry, what did Justice Kelly look at when, to come to the conclusion that it was a bald assertion of forgery?
The affidavit from the son and exemplar signatures.
And an appended agreement, right? I mean, the affidavit had the agreement attached to it.
And
didn't
an
it?
affidavit from Tremarchi.
And an affidavit from Trimarchi, which the
I'm
affidavit
trying to
from
explore the
Trimarchi
contours of your argument that there's no contract in evidence here.
I don't think that you can put a document before the court without some authentication of the document, like a business records exception.
That's not authentication, that's hearsay.
Yeah, that's an exception to hearsay.
But that's what brings the document into court first, and then we can look at the document and say, this is wrong, this is
For
right.
trial purposes or for motion practice?
For anything. I think you need, look, we can all
But
agree that
let's
if.
say they had the person who signed it, and they just came in and said, yeah, I was there, and they signed it.
Totally different
Now,
case.
yeah, but then, don't you have a hearsay problem?
If they had the Trimarchi affidavit
But you
and
need
that
both,
person, then
then.
yes, they have the hearsay
But you'd still
problem.
need the business exception. If you had the person who came in and said, I was in the room, this person signed it, would you still need Trimarchi to say the two parts of the business exception?
Yes. Yes, and I think we can all agree that if the decedent sued in New York County as here, and the defendant said, hey, this is the wrong venue, this should be in Nassau County, and they opened their drawer, and they pulled out the night file from the drawer, and they looked, and there was just a blank contract with no signatures on it, they wouldn't bring this motion. They wouldn't say, hey, here's a contract, let's put this before the judge, and let's use circumstantial evidence to show somehow she got into this nursing home, here's a blank document, but it does have this on it, let's put it before the court.
That's
It is a
obviously not
contract.
what we have here, right?
Well, we're one step above that, and some people might think that that's exactly what happened. They looked in a drawer, they found 2 out of the 3 admissions agreements. She was admitted 3 times to that nursing home. The most recent one
Where is that in the
missing.
record that she was admitted 3 times?
It's in the decision, and it's in our papers.
Because I saw in your complaint, it has the dates that she was resident of this particular facility.
It has the dates where there was malpractice committed, yes.
But it doesn't say when she went in and out, right? So it seems to me that maybe 2, and I guess it's not really relevant, but these 2 cover the stays for those periods of time.
Well, the third admission was after these 2. So in the last argument, we heard that the most recent argument, the most recent agreement should be the operative one. We don't have that at all to look at here. We don't even have the exemplars from the last agreement that she signed, the Morales signature on it. We don't have any of it. Morales' signature on all of the contracts that they did provide looks exactly the same. It looks like that could have been done at any time
So
and any
I'm a
place.
little confused on some of this chronology, but is the position that she was brought to this facility, or she herself came to this facility not wanting to be admitted, but they admitted her? I'm not understanding.
I mean, I don't know the answers to that, but I can assume no one wants to go into a nursing home, and I assume at 89 she was brought there, but not against her will of any kind. It's just unclear whether she ever signed any.
Your argument was that it is a forgery. Your argument wasn't that she wasn't competent to have made these decisions.
No, that's not our argument.
Yeah, okay.
Well,
But
where
it
does that
does-
leave you ultimately, if there's no contract?
In New York County, litigating a malpractice case where we started.
Right, and that's what's different, it seems to me, about this case. In an ordinary contract case, the rights are basically defined by the contractual agreement, and you're not going to really say part of this is good and the venue clause isn't good. But you have a separate freestanding malpractice claim that this admission document really doesn't affect at all, right?
Well, that's one way to look at it, although you don't want to really
I'm just
hear
saying
my
it's different
opinion on forum
factually.
selection clauses.
It's
'cause-
different factually than other cases like this with venue selection clauses, because the contract really isn't the operable document giving rise to the right you're trying to enforce, or the wrong that
In
you're
other
trying
words,
to
the
remedy.
worst thing that could possibly happen, that you all could do to my case is move it from one place to another where we'd still be litigating the same
No, I
issues.
think the
That's
points. No, I think, I may be wrong, but I understood these points that are going back and forth with you are, if you're challenging the signature, and the signature is a forgery, or not the decedent's signature, let me put it that way, and not with any authorization on behalf of the decedent to sign, that then there was no written agreement, and so then it's what claim survives. I think Justice Garcia is pointing out that there may very well be at least one claim that survives, even without a written agreement. That was the point, not about the
Yes,
form
without a
selection.
written agreement, we still have a same
malpractice.
medical
It's about
a
malpractice case, but we're
freestanding
trying it
That's
in
the
Nassau
And that's
County.
unusual in a contract venue
That's the point.
situation, where you're enforcing the rights of that contract. You're not enforcing anything under that admissions agreement.
Right.
You have a freestanding malpractice claim.
Yeah, I don't know that much about other contracts. I mean, I'm a personal injury lawyer, but I assume you're right when you say that. I just think we never reached the issues in this case of changing venue based on what they've provided and what they started in court, and we should be back in New York County. Thank you.
Thank you. Thank you, counsel.
No rebuttal, Your Honor.
Yeah, I don't think you asked to save any.
I did not ask, and I was thinking that should I, but I'm going to say no, thank you. I appreciate it.
Thank you.